And yeah, okay, whenever you're ready.
Hi, my name is Attorney Jonathan Sauer, and I'm going to be giving a seminar on January 12, January 13, and January 19 of 2019 to help homeowners have specific strategies in dealing with their home improvement contracts. What I'm trying to avoid and help you avoid is getting into certain situations that will often develop on an addition or on a second floor, and to try to give you some strategies to give you the best possible result. There are a lot of things I'm going to talk about during the seminar. I can't talk about all of them right now, but I want to make 4 points. And these are the 4 points I want to make to give you an idea about what we're going to talk about. Number 1, we're going to talk about how the project gets designed. Number 2, we're going to talk about how the contract itself gets prepared. Number 3, we're going to talk about a budget and how much money you should borrow from the bank. And lastly, we're going to talk about contract administration and the things that can be done to maximize the chance of giving you a good result. Number 1, who prepares the design? Typically what happens and the model for this particular talk is a significant addition or a second floor on a ranch house. A contract in the amount of $150,000 to $200,000 or thereabouts. Typically what happens is if the owner has an architect involved at all, the architect will just provide what are called architectural drawings, which by and large are essentially pretty pictures with dimensions on the exterior part of the building. Well, the problems with a home renovation and addition or a second floor aren't on the outside, they're on the inside. And so while it looks nice to have these drawings, this isn't anything that's going to really control what a contractor is going to do when he builds the building. I have no problem with having architectural drawings, but in construction we have what's called a performance specification. And I think that in addition to the architectural drawings, and for bidding purposes, that the architect should give a lengthy paragraph stating what he wants the construction to be. This is going to be a second floor addition. It's going to be 65 feet long, 35 feet wide. It's going to have 4 bedrooms, one of which is a master bedroom, which has a walk-in closet. It's going to have a bathroom with Kohler fixtures, including 2 vanities and a sink and a tub and a shower, and et cetera, et cetera. Going to a second floor when you've only had 1 floor, now we're going to have to go into two zones for heating and air conditioning, which is a reasonably complicated and sophisticated thing. But to have the architect just give a word description of what he wants the construction to be, this will be helpful for bidding purposes. Then at such point in time, as you do get bids from contractors, then the contractor will flush out the remaining aspects of the construction, and the architect can look at the entire package, including the bidder, and say, well, I think this one is a better deal than another. And one thing to keep in mind, the lowest bidder is not often the lowest bidder. If you have somebody that's $20,000 low, and you say, well, I'm going to get everything I want for $20,000, it's not likely to happen. In fact, the bidder is likely to figure he's going to make that $20,000 and more on change orders as you go along. So the lowest price bid is not necessarily the best bid or what will ultimately be the cheapest bid. The second mistake that people make is they allow the contractor to make the contract. Now, Massachusetts home improvement contracts are subject to lengthy statutes, lengthy regulations, and in fact the state actually provides a very basic contract, and I think the paper gives a reference to where that can be found. But the state says in those materials that while this contract complies with the basic home improvement contractors, it's not designed to protect the interest of homeowners. So that's where you have an attorney come in and draft a contract for you. That will be something that will be given to the bidders, so that they'll have the architectural input and they'll have the contract that they're going to be performing. So we won't have any discussion about any of those things when we get the bids, because you already told them what you want. There are any number of provisions that you should have in the contract. They're technical, and I don't really have the time to go into them other than just list them. We want to have a schedule of values, which is breaking down all of the major items of construction, assigning a dollar value. The purpose of this being to try to make sure that you don't get overbilled by the contractor as the job goes along. We call that front-end loading. We want to have retention. Again, this is something that is in construction. 5 or 10% of the job is retained until the project is complete. This is the money that will be available to perform what's called the punch list, the last remaining items to get done to finish off the job. There'll be other provisions, a liquidated damage clause, so that the contract will say when the work starts, it's going to state when it ends, and then there'll be a provision that if the contractor overruns, he's going to be paying you $300, $200, $400 a day. Because by my experience handling any number of these jobs, quite often the job just goes along and it reaches a certain level of performance, 75, 80%, 85%, 90%, but it never really gets done. The contractor has moved his crew off to another building, and the thing just goes on and on and on and on. So having a liquidated damage clause, again, this is something to help keep the contractor focused. We'll have an attorney's fee provision. So if you have to sue the contractor to get him to perform to the terms of the contract, you get your attorney's fee. And which is something he'll have to think about, and the lawyer's going to think about, is his position really that good that it's worth paying 2 attorneys for? You only want to pay 1 attorney, and you don't even want to do that. But if we have an attorney's fee provision, this will, number one, help finance any litigation we have. But basically, we wanted to dissuade the contractor from taking you for granted and not performing in the terms of the contract. The last point so we have that. We have the design part, we have the contract part, and you're going to have the architect do the design as I've indicated, and to review the bids as they come in from the bidders. And it's good practice, particularly if we're dealing with higher dollar value contracts like $150,000 to $200,000, to have the architect review the requisitions, the monthly invoices from the contractor, again, to make sure, have them come out to the house to make sure that you're not being overcharged, and if there are any defective issues of construction, the architect will pick up on them. They'll be a lot easier and less expensive to fix earlier than they might be afterwards. Your lawyer's going to draw up the contract, and your lawyer will help you with contract management if issues come up. We'll be concerned about things like lien waivers to make sure we don't have mechanics liens on our property, and there'll be a number of legal technical things that you can be assisted with. It's not going to be an enormous figure, but it's going to be just enough information so that you get what you're paying for, and the contractor knows that you're a significant person and you're not going to accept substandard performance. We're going to also talk about, the last thing would be the budget, and that's how much you go and borrow from the bank. You don't want to go and borrow from the bank the actual amount of whichever bid you're going to consider, because as a practical matter, all jobs have change orders. They have extra work that has to be done. You know, your contractor may be ripping off a roof or exposing walls on the first floor that you have right now, finding defects and things that have to be fixed as part of this construction. Oftentimes, and usually, if there are changes in the building code at such point in time as you do a significant renovation, you may have to, up the general level of the construction, insulation, things of that nature, which may not be there, Tyvek, a number of other factors. So you should at least have a factor of 10% for change orders. It might be more, but at least have that. You should also have a certain amount for the architectural services and the legal services, so that you have an entire package. So just to summarize, we're going to talk about how the design gets done and how it gets reviewed. Secondly, we're going to talk about how a contract gets prepared and some of the issues and the clauses that need to be in the contract. Thirdly, we're going to talk about effective contract management and having the architect review the monthly requisitions and the attorney get involved with any problems as they develop, because early problems are less expensive and less significant than later problems. And lastly, we're going to talk about the factors of dealing with the bank and how much money you should borrow, so that you understand what the real cost of construction is. The real cost of construction will include these factors that I've talked about. So we're going to talk about any number of things. We're going to give you a lengthy paper, and on all my seminars, my deal is that you read the paper. If you have any questions at all, you call me up and I'll try to explain it. But again, the purpose of this seminar is to put you in the position that when you ultimately are dealing with a contractor for a significant home improvement project, that you have a pretty good idea what you're doing, you understand what the issues might be, and we're going to take steps to make sure that these issues, to the greatest extent possible, don't interfere with your job, and you get what you paid for at about the time you expected to get it, and then you don't have to come and see me later on to talk about the different types of problems that can arise if we don't follow these different procedures. So I'm hoping you'll come. I think it'll be worthwhile for you, and thank you for your time.